This is what you've been living for. Like, you've been doing this, you see other people get into arrangements where they're getting sponsored, their content, you build up this audience, and now finally the days come that you are going to be a brand ambassador, or you have a brand deal, or you have a sponsorship. Someone's willing to sponsor your podcast, sponsor your YouTube channel, sponsor your Instagram page or your TikTok, and you've arrived. And so you're eager. And so the first thing you're going to do is, when they get their agreement, you're just going to sign away all your rights. Sometimes that's not a necessarily good thing, because there are certain terms in these agreements where you have duties, things that you have to do, and things that you say and can't say. So it's a good idea for you to understand the terms of the agreement. So we're going to go through a typical agreement. The way this video is going to go, I'm going to start with just the basics of contracts. I know it sounds really basic, but you need to have a foundational understanding of what it means to have a contract. And you can use this for other parts of your life too. And then we're going to talk about just the basic terms. It's going to be in every agreement. This is something you're going to know. What do you have to do and how much you're going to get paid? The basics. And then we're going to go through some of the details, some of the language that you're going to see in there that has rights that you may give away, that you should know about, may have duties or responsibilities that you should know. Can mess up your agreement. And then finally, we're going to go through just the standard language that's in all agreements, whether it's a brand agreement, a sponsorship agreement, a real estate deal, employment agreement. This language is in all agreements. You've probably seen them before and you don't know what it is, and you just skim over it. So while you're watching this video to learn about the basics of brand deals, you can use this in other aspects of your life. So you ready to get started? Grab your pen and pad, or your notes app, so you can take notes if you need to. And if you love this video, if you like what I have to do, I want to invite you to join the J Squad, which is my community I have here. And I'm be going through some more of band source. I have lots of stuff here. So check out this channel and subscribe if you're interested. And then also share with fellow creators. All right, so let's get started. The first thing, let's talk about a contract. So what is a contract? Now, a contract is an offer and an acceptance and consideration. So you need to have all three in order for there to be a contract. So let's say, for example, I tell my neighbor's son across the street, hey, I'd like for you, his offer for you to it's spring cleaning time, to rake the leaves off of my front yard. And the neighbor's son says, okay, sure. That's not a contract until I offer something of value. So for example, let's say a week passes by and they still haven't done it. I can't go to the neighbor's son and say, hey, we had an agreement, we had a contract. If I didn't do anything, if they didn't get anything for in exchange for it, it does not count. They don't have to listen to me whatsoever. When I say, okay, I'll pay you $50, that's the consideration. The consideration could be $1. The consideration doesn't even have to be money. It could be something of value. I could say, you guys can have all the mulch that's grounded. Y'all can have it because I see you guys are harvesting. And the value of that mulch is maybe $100. You and your family had to go buy it. You don't have to buy it. You can have all of mine. So even though I'm not giving them money, I'm giving them something that's of value. That's the consideration. Now we have an agreement. However, that agreement was oral. So that's why agreements have to be written, because let's say the neighbor does it and I just ghost on them. I don't give them the mulch. I don't give them the $50. They go to court and sue me. The court's going to say, well, did they really say that? And I can say, no, they didn't. That's because it's just oral and they're going to kick you out. You have to have something in writing in order to make it binding, in order for you to actually, if you have a dispute, to take it to court. So that's why you have an agreement. So that's the basics of contract laws. So free for you. You don't have to go to law school. Now you know. Now let's talk about the terms, like the basic terms. Like in a contract, you're going to have, the header is going to say sponsorship agreement, or whatever it's going to say, brand agreement, whatever. That's going to header top. Then the next two paragraphs is going to say the party is going to be you, and then either the brand or the brand's agency, or maybe with your agencies, perhaps. That's the agreement. So it's usually blank. It's usually a boilerplate. They're going to fill it in. Someone's going to type in your name and type in the brand's name. All right. The next thing, we're going to talk about the scope of work. Like, what do you have to do? It could be you have to go to an award show, you have to go to an event, you may just do a video, a reels, a TikTok, a blog article, you know, various different things you'd have to do for that. And in exchange, you have the payment. And so this is how much you're going to get paid, and what rates, and how much each month if it's longer than a one-off deal. Now, because a lot of these brands use boilerplate language, you're going to see the fine details regarding the scope, what you have to do, the payment terms, all those details details are usually included in the back in an exhibit or in an attachment or some other document, a schedule that has more details in there. Maybe a chart, and they'll fill it in. That's because they're dealing with lots of different agreements, and every creator, every deal is unique to the brand and unique to the creator or the influencer that they're working with. Now, what the details may say also include, it may say stuff like when you're going to get paid. A standard is net 30, meaning 30 days after some event, triggering event. That triggering event could be when they receive the W-9. It could be when you actually post the article, the blog post, or the video. It could also be when you get final approval. So that all of that is going to be in the schedule or an exhibit in the back in terms of like when you get paid. So you're going to look at that, and also going to tell you the scope of what you have to do, when you have to do it, whether approval is required. So that's where that. So that's just the basic. The first two clauses are going to be that. Now let's get into the next set of sections. It's going to have a little bit more details regarding your rights and responsibilities. So this is where we talk about like who owns what and who has to do what. Like, so more than just like, you know, the basic stuff. So the first section we're going to talk about is usage rights. So usage rights in terms of like the content that you produce for them, or whatever you're filming, or whatever, or your performance that you have to perform, and you'll be capturing that. How can that be used? So it's usually understood that when you find an agreement, it's for the term of that agreement. It's usually 0 to 3 months, maybe up to 6 months in terms of the time. And then your content's usually going to be used digitally on their socials, on your socials, maybe in email campaigns, maybe in an ad, but it's usually confined to digital spaces. Now, you may want to have it, the brand may want to use that content for longer than 6 months, maybe for a year or longer, and they may want to use your content in other spaces, not just digitally. Like perhaps they might want to make a print ad, they might want to do a billboard, they want to have in-store, they may want to do a broadcast or radio ad. So in which case, the schedule, which mentions that if the language has these other things and you have representation or you feel comfortable enough, you may want to negotiate a higher cost. And why? Because the amount of money they'll make by having a billboard in Times Square from your video, if you're really, really great, is so much more than just your followers and their followers in a digital ad campaign. It's more limited. So the fact that it's going to get broader reach and they may make more money from your content means you should be making more money. So that's why you might want to negotiate more for a longer period of time or for expanded use of your content. So other types of rights that are mentioned includes the copyrights, meaning like who owns the content. A lot of times it'll say that the brand owns the content, but that the creator can use it on their socials and use it freely as well. Or it may say that you guys own it equally, or it may say that the creator owns it, and in which case the brand is only licensing out the content. Other rights is the rights for exclusivity. So a brand may say, especially if it's you're in a really highly coveted person and it's not a good idea for you to be doing their ad and the next minute you're doing a competitor. So they may say it's exclusive. Now, if it is exclusive, usually the exclusivity lands for the time, and most people just doing it until you actually post it and then it's done. You're free to go do something else. But if it's an ongoing brand ambassadorship for like 6 months to a year, for example, they may have a clause that say you can't. They're foreclosing, they're stopping you from making money. And if they're stopping you from making money, if you have an agent, or if you feel comfortable enough, you might want to add a premium meaning extra money for the fact that they're asking you to be exclusive to them for the terms of that agreement. Then you have the duties. Now, duties is something that you have to do under the agreement. That's why I say it's important that don't just look at how much you're getting paid or what you have to do when you're done. The duties may include stuff like Federal Trade Commission disclosure. So if you are dealing with a US-based company and you're a US-based creator, we have Federal Trade Commission actually regulates or actually oversees and can actually fine creators, and they have fined creators $1,000 if you don't do certain things, certain disclosures. So there's not just fining the brand, they're also fining you. So the brand wants to cover itself, so they'll say that you're going to abide by all the disclosures. Another duty may have a duty to not disclose. So it may be a confidentiality clause. You probably heard of the word NDA, a non-disclosure agreement. That's a separate standalone agreement that you might hear people who contract with one another get in to make sure they're not disclosing or sharing things out that's given during a portion of their agreement. So the confidentiality would probably say don't share secrets, don't share certain like trade secrets. And I think it may even say don't share your rates because they're negotiating with different creators. They may be a creator that have a similar amount of followers as you, but they may be getting getting paid more money or less money, and so that could be hairy. So that confidentiality clause may specifically say do not share your rates. Another duty is the duty for, it may be a non-disparaging clause, meaning you can't say anything bad about us, and that's usually going to apply to those of you who have a long-term brand deal or brand ambassadorship beyond 6 months. You can't be making money from the brand and then you're bad talking them on TikTok. And the other thing you might see is a morality clause. Sometimes I was in agreement with a brand, and it said that I had to, keep myself in a certain standard, and I couldn't, I don't want to embarrass the brand because they're associated with me. I'm their brand ambassador. So I want to avoid, saying things that against certain sexualities or racially harm, or go out and rob people or do any crazy stuff. You don't want to do that because it's going to reflect bad on the grant, and they can end the contract of that. And then finally is the termination, which means like the rights or when you can terminate the clause, and the duty is to give notice. Usually like something like 10 days. Usually not a long time that you decide for something that's not working for you, or you get ill and you can't meet their agreement anymore, or things change with you. You want to terminate. You have to give them a certain amount of notice, and they have to give you a notice, which is great because most employment agreements, you don't get an actual agreement. Once they hire you, that's it. You get paid at the end of the week, and if they want to fire you, they don't have to give you notice. They can fire you at the drop of the hat. Having the termination clause in agreement is actually a perk. That's great if you see that in there. So that is the other thing. So then they also may have talk about equipment. So you may see a clause that talks about saying that you're going to use your own equipment, your lighting, your phone or your camera, your editing software, your editor, whatever you're going to do to you on your own, unless it's specifically said for this agreement, I need a GoPro because I'm going to be skiing and I don't have a GoPro. And so the brand may provide you one. But if it's not specifically, it's assumed that you use your own equipment. Finally, usually an independent contractor. So you have the duty to report your own, because at the end of the year, the brand takes all the different contractors and creators that they worked with, and they report it. In the United States, it's going to be to the Internal Revenue Service. They say, here's how we paid. Here's the Social Security information. That's why you fill out a W-9, because they have to report everyone they paid. Now that the IRS knows, they also know you made the money. So you have a duty when you're doing your taxes in the year to make sure that you let the IRS calculate that in your income that you receive in revenue, because you have to pay taxes on that. So those are the different specific terms and rights and responsibilities and duties that you should be aware of when you in these brand deals. Now let's talk about the just general language that you're going to see all the time in most agreements. One, you might see mentioned to attorney fees or legal fees. If there's a dispute, whoever loses has to pay the other person's attorney's fees. So if you get in a dispute and I have to hire a lawyer and I win, then the brand will have to pay me. If there's a dispute and the brand wins, you have to pay the brand's attorney's fees. So that's something you really need to be careful of and be aware of. The next thing is you might see a thing called warranties and representations. Warranties and representations is kind of like you warrant that you have the right and represent that you have the right to enter this agreement. And similar with the brand. So for example, let's say that it's an agency, and the brand told the agency only hire Canadian American influencers, and you're Canadian, and then the brand's agent can no longer come to you and say, hey, we made a mistake, we already signed this agreement with you, but we were only supposed to sign Americans, you're Canadians. At that point they breached it. Their warranties represented, because when they entered into the agreement, they warrant and represented that they can enter the agreement. Now from the creator side, you may have an agent that you work with, and you negotiate this with the brand one-on-one, and you leave out your agent, and the agent want their cut. So the agent can't come and say, we had an agreement exclusive, we're supposed to negotiate all brand deals with her, and so you have to pay us, not pay her. The brand could then tell the agent and you, like, that had nothing to do with us. When you sign this agreement, you represented and warranted that you have the right to enter this agreement. So you deal with that with your agent. So that's what the representations and warranty section means. Force majeure means like if there's anything that's out of the control of any of the parties, that you can get out the agreement. So let's say, for example, there's a pandemic, so you can't make it to the event because all the airports and everything was shut down, or there's a strike, that we just came out from the actors strike and the writers guild strike, so you can't cover this event for this brand because it just didn't exist. Or there's something else, there's a tornado that shut it down, so you can't make it to the event, or you can't do something. So stuff that's beyond your control, that's what the force majeure. No assignment means that the agreement is with you. You can't say, man, I can't do that. Let me get my boy. We do the same type of content. So my boy can do it for you. You can't assign the contract to somebody else. It's only between you. So that's what the non-assignment means. Severability. They can't say that if a court determines that a portion of the contract is not legal, you cannot, the rest of the contract is whole, irrespective of the fact that you can sever that one part that's not legal. And related to that is the counterpart. So let's say you start this agreement and there's an attachment, then there's addendum, then there's an email adjustment. So all those various different counterparts still are part of the whole agreement. They still constitute one whole agreement. If there's a dispute against one piece, it's all part of that one agreement. Severability. Electronic signature means that, because back in the old days, contracts had to be signed with your Jan Hancock on an actual piece of paper written. So in this digital era, electronic signature is when you're agreeing that my electronic signature counts as a signature, so I won't dispute, like, this contract doesn't work because I didn't actually sign it. You agree that the electronic signature counts as an actual bounded and agreed upon agreement. No waivers, meaning that if you waive away portion of rights, if you waive, let's say, for example, payment terms, you say, well, instead of getting paid net 30, they say, can we pay you net 60? And you say, okay, sure, pay me net 60. Even if they waive the rights, or you waive the rights to get paid within 30 days to 60 days, the rest of the agreement still applies. Even if you waive one portion of it, the rest of it still is still good. So that's what the no waiver clause means. And you don't have an attorney, and so I'm like, that's it. So we've gone through all of the terms of a basic sponsorship or brand ambassadorship agreement that you will receive if you agree to collaborate with the brand to promote their product or service. And now you know, knowing is half the battle. I don't think there's a lot of lawyers on YouTube that are educating fellow content creators. I'm a content creator as well, so I don't think there's a lot of us out here who are doing this service. So I'm doing this for you, so that's how you can repay me, is give me a subscribe and share this video. All right, stay tuned to this channel, and we'll keep it going. I'll keep you educated. I'll make sure you know what you need to do. All right, and in the meantime, I have more videos in this. I'm gonna put, again, this is a series. It's going to be right here, so you can watch more videos in this series telling you what you need to do, your rights and responsibilities as a content creator in the creator economy. All right, change your gat. Talk to you soon. So that's